Hello and welcome to this webinar where we're tackling the topic of long service leave. I'm Alison Williams, Managing Editor at Australian Business Consulting and Solutions. And with me today is our own IR expert, Paul Munro, who has a lifetime of experience in answering employers' questions on just this sort of complex topic. Welcome, Paul.
Hi, Alison. Hi, everyone.
So we get a lot of questions on this topic of long service leave, and you and I, Paul, we think it's because long service leave is something that employers really only encounter occasionally. You know, by definition, it's for long-serving employees, and with the increased mobility between jobs and with non-traditional types of work increasing, it's just not something which is super common.
No, I think after dismissal questions, long service leave is probably the next most asked question by subscribers. It's I suspect it's people don't come across it all that much and probably think the legislation may have changed when, funnily enough, there's very little legislation change that occurs in the long service leave space, although Victoria may very well be about to change in their jurisdiction. But and I think it's the fact that it doesn't happen very often in a place that just raises that particular question in a person's mind or in an employer's mind.
That's right. And because it's very much a part of the Australian employment landscape, even though it doesn't happen, all the time, you still really do need to know the basics. So that's the whole point of today's webinar, and I'm going to run a number of questions past Paul, and he's going to provide the answers. So here's our first question. About long service leave pro-rata after 10 years service. So how should an employer calculate pro-rata long service leave for an employee who has resigned? Is it based on completed years of service, or is it based on years and months of service?
It's one of those things where, it's funny, when I first got the question, it didn't dawn on me that there are each state and territory, and this is going to be a common theme through the webinar, is that each state and territory has its own long service leave legislation, so it's something specific to that particular jurisdiction where the employee is employed. But I must admit, I just originally thought that it was based on years and months and days of service for basically the whole period. But surprisingly, there's some difference, particularly when someone's been there longer than 10 years. So I'll run through the different jurisdictions as to how you calculate pro-rata long service leave after 10 years. For example, in the ACT, employee with 7 years or more service on termination is calculated on completed years of service, which is 1/5 of a month's leave for each year of service. So that's years of service, each completed year. In New South Wales, between 10 and 15 years, it's calculated on completed years and months. And then after 15 years, it's completed years only. So New South Wales just adds another complication to it, and having a two-tiered arrangement depending on the length of service. In the Northern Territory, the employee has completed 10 years, but the employer is entitled to 1.3 weeks leave for each completed year of service. So that's another one where you can disregard the months of service as such, so that if someone has completed 11 years and 11 months, it's 11 years service. In Queensland, it's the same as in New South Wales. It's completed years and months service between 10 and 15 years, and then only completed years count after 15 years. South Australia is the same as the territory in the ACT, and that is that it's 1.3 in terms of the way that it's calculated is it's for each completed year of service, where in South Australia it's 1.3 weeks leave for each completed year of service. In Tasmania, it's calculated on completed years and months service. In Victoria, it's based on 1 week for each 60 weeks of continuous employment. That's after 7 years service, so that's the same all the way through in that particular case. And in Western Australia, after 10 years, only completed years count. So if you've got people in different states and different territories, if you're covering more than one jurisdiction, double check the jurisdiction that the employees are in, because you may need to. It's more an issue with those states that have completed years and months. A lot of the other states and territories seem to have only completed years, so just be wary in places like New South Wales and Queensland where it's years and months as well.
As I'm listening to you there, Paul, I'm thinking, well, this is why we're having this webinar, because it just sounds confusing, but you really just need to note which state and territory you're in and really, only apply that one literally.
Yeah, for an area that is a relatively, you'd think on face value, an uncomplicated question, yes, it certainly shows up the vagaries and probably, as a lot of people would say, the necessity for a national standard of long service leave.
That's another story. Okay, on to our next question. Can longer service leave be taken by an employee who's on workers' compensation? So this is a sort of request that's often made by employees they've accrued long service leave, but they may be suffering financial stress because they're on workers' compensation, or there could be some other reason, but mainly because they're on workers' compensation, receiving workers' comp payments, which are of course less than their normal pay. So is this allowed by the Fair Work Act? If you read the Act, it seems to say that employees are not allowed to take paid leave when they're absent on workers' comp.
Yeah, that seems to have confused things a little bit. Most of the issues relating to long service leave, or leave in particular, and accrual is based on accrual of leave, such as with annual leave. There's been quite a few cases that are dealing with this issue of whether or not people accrue annual leave during workers' compensation. Long service leave is something that is pretty much been taken care of in the continuity of service definitions in each particular state and territory legislation. Most are silent on the issue of taking leave, hence we get a few questions on this as to the accrual part's covered generally in long service leave legislation, but when someone's on workers' compensation, but not whether or not someone can take it at the same time. Generally, most of the legislation is actually silent on the point, although some workers' compensation legislation in a couple of the states does make specific reference. Where there's an absence of a specific provision, you can presume that the person can take workers' compensation because there's nothing that specifically prohibits it. In Queensland and New South Wales, there's the workers' compensation law actually is where this is covered off, and it does permit taking leave during an absence on workers' compensation. The other thing that gets questioned is the long service leave in lieu of the workers' compensation payment. Well, no, a lot of employers seem to be under the impression that someone's receiving a double payment for the same thing. Well, in fact, they're two payments for two different entitlements. So that someone who is taking long service leave while on workers' compensation will continue to receive their workers' compensation payments as well as the payment from the employer for the period of long service leave. It would seem the only state that prohibits taking long service leave while absent on workers' compensation is in Tasmania, so it's quite specific about getting a dual entitlement during a period of workers' compensation. So the interpretation in that state is that a person can't take long service leave during a period of workers' compensation. But in most other jurisdictions, or every other jurisdiction, the ability to take leave during workers' compensation, there's nothing that would appear to prohibit it. And as I say, in a couple of states, it's actually specifically provided for that it is permitted to take leave on workers' compensation.
Okay, right. So that's cleared that one up. Generally, yes, an employee may request and take long service leave when they're absent on workers' comp. So let's go to our next question, which is, does parental leave count as service for accrual of long service leave? And this question relates to whether an employee is entitled to be paid out long service leave if they resign after 10 years service, if during that time the employee took 12 months parental leave. Can you explain how this works, Paul?
Yeah, the question usually comes up in relation to when someone has an entitlement, or say they've been there, it started 10 years before, and they put in an application for a long service leave thinking that they may have 2 months or 3 months, whatever the case may be in the state or territory that the entitlement is. But if they've taken a period of parental leave, unpaid parental leave, then it becomes an issue of, does that period count as service? In other words, part of the 10 years, or if for example, if they took 12 months unpaid parental leave, does that mean that they've actually only completed 9 years service, which means, for example, if the legislation says you've got to complete a 10 years service, then you've got to wait another 12 months before you can actually access taking leave. It also can become an issue depending on pro-rata entitlements on termination, depending on the circumstances as well. So once again, as mentioned before, it generally depends on the legislation, but most of the legislation, long service leave legislation in the states and territories, doesn't make specific reference to parental leave. It's usually in relation to the continuity of service provisions in the Act, in the relevant Act, about a reference to unpaid leave or leave of absence with the permission of the employer or authorised leave of absence. So unpaid parental leave would fall into that description if that's the term, that's how it's expressed in the particular relevant state or territory legislation. So it's pretty much across the board that that unpaid parental leave doesn't count as service. Once again, because the continuity of service provisions or definitions in the respective legislation in the states and territories just refers to unpaid leave as not taken into account when determining total service. So, for example, Victoria, though, is one of these areas where this is a potential area of change with currently legislation that's being determined or going through the Victorian Parliament, where it still won't count as service, but there's been some issue there where if a person is on unpaid parental leave for longer than 12 months, there seems to have been an interpretation developed down there that that actually breaks the leave altogether, which I must admit was something that was not something I would have thought was the case. However, that's the government down there is acting to change that, so that they're certainly not changing the impact that unpaid parental leave has on continuous service. It still won't count as service, but they're trying to close a loophole that applies there, where a person, if they take longer than 12 months unpaid parental leave, could in fact have to start all over again rather than having the previous service count. So that's something to look out for with the current legislation that's before the Victorian Parliament.
We're done. Thought there might have been some more on that. Okay. All right. There's the bottom line there. So yeah, it does not accrue. Question 4. Does a public holiday extend leave? So given that we have around 10 public holidays every year, it's fairly probable that a public holiday will fall at some stage during the time an employee is off on long service leave. So the question is, does a public holiday extend the total amount of leave? For example, if Easter falls in the middle of the period of leave, will it be extended by that number of public holidays at the end? And if it is extended, then does that only apply if the public holidays are falling on days that the employee has ordinary hours of work?
Well, certainly the public holiday would have to fall on a day that the employee normally works. So, for example, Easter Saturday is a public holiday in a lot of states and territories, but a Monday to Friday person, that wouldn't impact on their long service leave, nor annual leave for that matter, or any other form of leave, because paid leave only relates to ordinary hours or ordinary days that the employee is required to work or normally works under their contract of employment. But it's another one of those things that, and I think where this comes from too, is that the Fair Work Act has a provision in it about the effect that public holidays has on annual leave and personal carers leave, and that it extends the annual leave and the personal carers leave where the public holiday falls. In other words, it takes precedent over the day being a paid day of annual leave or personal carers leave. Whereas with long service leave, like a lot of things to do with long service leave, it's depending on the particular jurisdiction. Most of the states and territories do take into account an extension when a public holiday occurs during a period of long service leave. So that includes the ACT, New South Wales, Queensland, Tasmania, Victoria and WA. So out of all of that, the only two jurisdictions where it's not extended, in other words, it's absorbed into the period of leave, are in the Northern Territory and in South Australia. So this is a question that often comes up too with companies that do operate in different states and territories, which a lot of our subscribers that are larger businesses these are the sorts of questions that come up. It's one of those things where if you do have, say, employees in South Australia or the Territory, and you want to put in a standard provision with respect to that in your, say, in an enterprise agreement or just as in a company leave policy, then it's South Australia and the Northern Territory. If you apply the extension of the public holiday to there, that would be fine in that that's something that's more beneficial than what's prescribed by that state or territory long service leave legislation. So for the sake of harmonisation or standardisation, if you do operate in multi-jurisdictional states and multi-jurisdictions, then that would be okay to do that. But you don't necessarily have to do that in South Australia or the Northern Territory.
If you've only got employees, say, just in those.
Well, if you've only got employees in that state and territory, then you don't have to extend long service leave as such if you don't wish to.
That makes sense. Okay. On to our next question. Is pro-rata long service leave payable when an employee resigns? And so this question relates to whether pro-rata long service leave should be paid out to an employee when they resign after, say, 7 years. The question, the original question was, the employer assumed that no pro-rata leave applied because the employee had resigned. They were leaving of their own volition. So what's the story with that one?
Once again, another one of those. It's deliberately actually picked questions that highlight actually the fact that never presume as the employer that that long service leave is something like annual leave under the Fair Work Act, that it applies to everybody across every state and territory. It's in fact one of the things to highlight in this webinar is that the questions highlight this whole idea that each jurisdiction is different. There's no logic to it. That's because there are state and territory different separate state and territory governments that have the ability and the power to be able to make these decisions of their own volition, or so you do end up with these differences. In some states, it doesn't matter whether who terminates the employment or for what reason, but there are a lot of states and territories where there's a qualification usually for an entitlement to pro-rata long service leave, usually along the lines of if the employee resigns because of illness or injury. So if there's a qualification, I think in this case the question is just relating to somebody who resigns and goes to another job. Certainly if an employee resigns because of a pressing necessity or an illness or carer responsibilities or because of an illness, they're the more obvious ones, then generally speaking the employee would be entitled to pro-rata long service leave if that's the circumstance surrounding the resignation. But in this particular case, it's just as if somebody who has served the qualifying period for pro-rata long service leave but just decides to leave their employment and obtain employment with another employer, whether there's a qualification involved in that. And once again, it depends on the state or territory legislation in respect to that. For example, in the ACT, this is where there's all sorts of differences that occur depending on the acts, the particular act. In the ACT, if an employer resigns if they've retained the minimum retirement age, and once again, there's something similar in the Northern Territory, and there's something similar, I think, in Tasmania as well. But so retirement is a reason that if that's the reason for the resignation, then that can qualify somebody for pro-rata long service leave. Generally, though, in the other jurisdictions, for example, in New South Wales, if someone resigns and goes to another job, unless they've served 10 years, then there's no entitlement. Once again, though, there would be a qualification if they resign due to illness or incapacity or domestic or other pressing necessity.
But after 10 years, it's fully accrued, really.
Yeah, after 10 years, in New South Wales, there'd be a qualification after 10 years automatically, no matter who, whether the circumstances behind the termination of employment. In Queensland, for example, it's the same as in New South Wales, where the employee basically has to resign due to illness or incapacity. So resignation wouldn't qualify in Queensland either, so New South Wales and Queensland are similar in that situation. In South Australia, there's a blanket qualification once they've reached 7 years that so long as the employee lawfully resigns or lawfully terminates their employment. That generally means provided that the employee provides proper notice, such and such things along those lines. So South Australia, it's not an issue as to whether if the person resigns and gives the appropriate period of notice, then they qualify for pro-rata long service leave there. In Victoria, it applies whether the employee resigns or whether they're terminated by the employer. So once again, there's a blanket entitlement in Victoria after 7 years where the person is entitled to pro-rata long service leave if they resign. Same in WA. Actually, WA has the same sort of situation as well, where the employment is terminated after 7 years for any reason other than serious misconduct. Then they're entitled to pro-rata long service leave. So if they resign, they are entitled to it as well. So once again, it's just another one of those particular circumstances where you do need to go through each particular state or territory circumstance to determine whether or not the person actually has an entitlement or not. Mm-hmm. And once again, don't apply if you're a head office in, say, Sydney or Melbourne or Brisbane. Don't necessarily apply the long service leave rules that apply in that particular state to employees that you have in other jurisdictions, other states and territories throughout Australia, if that's the case, because you could be in danger of breaching a particular state or territory long service leave law.
Yes, and we don't want that to happen. So we're moving on, and this is another resignation question. If an employer pays long service leave in advance, can they get that money back if the employee resigns? So it's a sort of scenario that can occur when the employer grants an employee early long service leave to take, say, an extended holiday, or they might be in the event of a serious illness. And typically, such an employee might have been employed for around 8 years, 9 years, something like that. But they're not actually entitled to. They haven't quite accrued the leave yet. So the employer's being nice, and they give them the leave earlier than they might have. But where does that leave the employer if the employee then resigns before the leave actually has fully accrued?
Well, it seems to be one of the few areas where there seems to be some commonality of provision amongst all the states and territory laws. If someone does take long service leave in advance, a lot of employers are reticent to do that because they're concerned that they won't be able to recover the money. I guess there's two issues in granting or in before granting long service leave in advance. One, whether you can do it. Well, certainly state and territory legislation appears to allow the employer to do that. Most of them make some specific reference to the fact that you can do that. So that's certainly, it can be put into the pot of monies or the pool of monies that are payable on termination, whereby the employer can deduct the outstanding amount or the outstanding balance between the amount of payable in advance and what the person would have received at the time of termination if the leave in advance hadn't been taken. I guess where the issue is to be careful not to grant too much leave in advance. Otherwise, it may be that the person has insufficient funds at the time of termination. So it's not as if you can take monies from once the pool of monies has been exhausted through other things as well. There may very well be other things if the employee not only leaves the employment under that circumstance. There may be other amounts of money that may be able to be deducted, which unfortunately, if there's insufficient pools of money, that leaves the employer short in that circumstance. So be very careful in that particular situation of granting too much in advance. But in doing so, if you do grant an amount that the person has already accrued, or even if you think that, particularly a lot of this happens around the 9.5 years or whatever is, say, within 6 months or 3 months or whatever it might be of when someone would have an entitlement. So it's generally not a major issue. It'd be unusual for an employer to grant somebody 2 months long service leave after, say, 5 years before they're entitled to it. That would probably be exposing the company to a risk that probably isn't worthwhile. So I would counsel against doing that. But certainly in circumstances, if you're contemplating wanting to do it for a long-serving employer who's given good service, that it's something that can be contemplated, in the knowledge that if something does happen, if the person does leave, you can recover the monies from monies due on term, or the long service leave in advance from monies due on termination.
Okay, that makes sense. Okay, we're moving it along. Number 7, does long service leave continue if an employee is re-employed? And by that I mean, say you have an employee who was employed under more than one contract of employment, but with a break in between. So in total, the amount of service can entitle the employee to long service leave, but does the break between the contracts also break their continuity of service?
Yeah, it's surprising how often this happens. A lot of people are re-employed, and I can certainly understand why an employer would re-employ somebody who's got particularly previous service of maybe 4 or 5 years or 3 or 4 years service, because they understand the company and they understand the practices, and particularly if the person has resigned and went somewhere else, or went on a holiday or did something else, and they seek re-employment with the company, it probably makes sense for the employer to re-employ the person in that circumstance, because the induction is less stringent, and the employee pretty much understands the culture of the organisation as well. It's more an issue that most of the legislation was actually changed in the 80s to reflect casual employment. That's certainly why most legislation was brought in this terms that talk about if a person is terminated and re-employed within X number of months. Usually it's 2 or 3 months, depending on, once again, that's another one of those things that varies, is the period of time. But most of that was relating to covering casual employment without making specific reference to casual employment as such. It was more to try to cover the nature of casual employment, or continuous casual employment, where somebody generally as a casual wouldn't be away longer than 2 months. They probably might miss a week here or a week there or a few days here. I mean, under the old provisions, if you're a casual, the nature of the employment basically meant you couldn't accrue long service leave at all, because it just the casual nature of the employment meant that there was no continuity of service. So long service leave was amended some years ago to acts were amended some years ago to take that into account. So that's fine where if someone is terminated by the employer and re-engaged. However, it doesn't necessarily cover the situation where somebody resigns and is re-employed, as to whether or not that breaks the service or not. Once again, that depends on the state and territory long service leave legislation. So, as well as the period of the intervening period. Certainly, the intervening period doesn't count. So, for example, if someone is terminated and re-engaged within, say it was 3 months, then the 3 months doesn't count. This is all about preserving what service the employee had with the company prior to the break in the employment. So once again, this depends on the particular state or territory jurisdiction. For example, in the ACT, now this is taking into account the circumstance where the employee has resigned, not where they've been terminated by the employer. This is where a circumstance where the employee has resigned, and this is the thing that can vary depending on the circumstances. If it's terminated by the employer, you can presume that if the person is re-employed within the 2 or 3 months, depending on the jurisdiction, that there would be continuity. It's the circumstance where the employer resigns that is the issue in this particular circumstance that creates this problem. Well, for example, in the ACT, if someone resigns, then that basically breaks the continuity of service. So the 2 or 3 months, or in this case the 2 months, becomes irrelevant. There's a break in the continuity, so if the person is re-employed even within the 2 months or the 3 months, the service for long service leave starts afresh. Same happens in New South Wales, exactly the same thing. If the person is re-engaged, after they've resigned, it doesn't matter what the period of time is, they start afresh. Same thing in the Northern Territory. Queensland is one of those ones that's different. Continuity is not broken if the employment is terminated by the employer or the employee if they're re-employed within 3 months. So once again, in Queensland, if someone does resign and they're re-employed within 3 months, then their previous service is recognised. South Australia, it's not recognised, so that's the same as in the other jurisdictions apart from Queensland. In Tasmania, it's recognised where the termination's for any reason, but only if they're re-employed within 3 months. So there's two things that involve, even with Queensland and Tasmania, is the person resigns, there is continuity provided they're re-employed within the specified period of time, which in Queensland and Tassie is 3 months. Victoria, it's not recognised. Same as in the other jurisdictions. Once the employer resigns, then that breaks the continuity of service. And the same applies in Western Australia. So out of all of the jurisdictions, the area where you would need to be mindful of previous service where a person resigns and is re-employed within 3 months is in Queensland and Tasmania.
Okay. All right. Well, look, we're heading towards the end here. We've got our next question. Can an enterprise agreement override state and territory law? So this question came up in the context of an employer which operates Australia-wide, which was negotiating an enterprise agreement with its workforce, and one condition which was proposed was to draft a term that would permit employees to cash out their accrued long service leave. But would this proposed term pass the boot?
Well, the short answer is no. The long service leave legislation in the particular state or territory applies because the Fair Work Act actually recognises long service leave as a matter that is not covered by the Fair Work Act. So there was a club, I think the first case of that was in New South Wales. A club in New South Wales wanted to allow cashing out of long service leave, which is actually contrary to the Long Service Leave Act in New South Wales. It doesn't permit cashing out of leave. So the Fair Work Commission said no, it can't change the terms of the enterprise agreement. It must comply, the long service leave terms must comply with the relevant state or territory legislation where the employees are employed. So the answer to that is no. Long service is one of those terms that you can't get. Unfortunately, you could get harmonisation in an agreement, but you have to make sure that it's more beneficial than in each, well, at least equivalent or more beneficial in each jurisdiction for it to apply across the board in your organisation.
Right. Look, we are going to have to hurry because we're running out of time. So let's gallop through this next question, Paul. Sorry to do this. Okay, if you're paying long service leave, this is our last question. Are allowances included in ordinary pay? So this is if somebody's paid, say, like an overtime allowance, per week. They might get $250 or something. Should this be included as ordinary pay when you're calculating the long service leave payment, say, on termination?
Once again, this is another one of these provisions where the definition of ordinary pay determines, in each act determines whether or not they're payable or not. Generally, once again, so in New South Wales, for example, there's no allowances are included. South Australia, they're not included. Queensland, they're not included. Victoria, they're not included. And WA, they're not included. But in the ACT, the Northern Territory and in Tasmania, they do include allowances or certain work-related allowances that would apply, like leading hand, I presume, is probably one off the top of my head I could think of that where it would be included in the definition of ordinary pay in those particular areas. So allowances generally, once again, depends on the jurisdiction. Generally, they're not included. The trap that a lot of employers fall into, though, is that I've noticed where there's been cases where the employer's paid, say, an overtime allowance, and which means that the person's getting paid to compensate for overtime being worked rather than pay per week the number of hours of overtime. They just pay an amount and identify it as an overtime allowance. If it's paid each week and it's not regarded as overtime, then courts have determined that actually, because it's being paid each week, irrelevant of how much overtime is being worked, it actually then becomes part of ordinary pay. So just be careful in what you call an allowance in inverted commas doesn't actually become something that is payable no matter what. In other words, whatever description you give that allowance, make sure the allowance is paid only under the circumstances under which the allowance is supposed to be paid. So be very careful of that situation.
There, and there's our bottom line slide. Okay, look, we are done. Thank you, Paul, for explaining the technicalities of long service leave. I hope you, the listener, can remember and use this information when you're next confronted with a long service leave problem. Don't forget, subscribers have access to the Workplace Advice Line. So if you have any further questions, it's free as part of your subscription. So goodbye for now.
Thanks, everyone. Thanks for
Bye,
listening.
Paul. Bye.